All right, hello, everybody. Glad to see everybody. It's about time we saw each other in person. I've got 8 minutes. I'll make it brief. All right, so those of you who don't know me, my name is John Sadler, Prescribed Fire Manager with the Florida Forest Service, and I'm here to provide an update for the Florida Forest Service. Full disclosure, I'm going to shorten my presentation, and then at the end we have a couple of attorneys here with the department. We have Darby Shaw and Kellyanne Kennedy, and they will talk to you guys about prescribed burner liability. So let's go ahead and get started so we can get out of here before the rain hits, maybe, or not. All right, so like Will, I do also have an outline. So I'm going to talk about, how our burning's going this year. Talk about any upcoming training. I know that has been brought up a couple times today, and go over our prescribed fire enhancement program. Talk about our current prescribed fire messaging campaign called Why Prescribed Fire, and then my regular burner review, as always. So it's been a pretty good year for burning. This is a fiscal year, so this goes from July to June. So 2021. We had 2.2 million acres, so that was pretty good, a little bit better than the year before. This year, we're basically right on track with that same numbers. I ran the numbers last night. Year to date, from July 1 last year to today, we're about maybe 30,000 acres difference from what we were last year. So we're about on the same track as we were last year. So it'll probably be 2.2 million acres again for this fiscal year. So good job, everybody. Give yourself a round of applause. All right, so certified burner training. I know this was brought up. Ben brought it up multiple times in the presentation for the PBA. I don't know. That's why the question mark is there. I still don't know, but I'm very, very hopeful that we'll be back on schedule this fall with our regular, starting in October through the winter months, ending in usually February. So hopefully we'll have those. We do 5 or 6 classes regularly, the regular locations. Depending on how everything goes, I may look and see if we can do some additional courses, because I know there's a pretty good backlog of that. So fingers crossed, we'll be back on track in a few months with that. Our prescribed fire enhancement program has been very popular the last 4 or 5 years. This particular year was low funding, so we didn't really spread it out too much among the other agencies. We kept it more in-house. Hopefully, and well, like Will was saying, we're waiting for the final budget to get signed by the governor, but hopefully I'll know earlier in the year, and we'll have this program up and running for this fall. So all the agencies that traditionally have gotten some funding, hopefully I'll have some more funding for you guys starting in August. Under our Why Prescribed Fire campaign. So this is, we just finished up our 3rd year of this campaign. It was a cooperation with Tall Timbers, and the previous years it was mostly social media, a lot of Facebook ads, YouTube, things like that. But this year, starting in January, beginning of the year, and it wrapped up mid-March, a little bit, about 2 weeks too late. We had all those fires in Panama City. We were kind of scrambling to get the ads turned off. But I mean, it's kind of a thing, right? So, you're promoting prescribed fire, which helps reduce that. And I guarantee you that stuff that burned in Panama City 4 weeks ago is not going to burn for at least another year. So, so it helps. But so we had this year we just did TV ads, TV spots, as opposed to doing paid social media. And so we did 4 TV markets. We did Tallahassee, Jacksonville, Orlando, and Tampa. I saw several of them during the news. I watched Channel 6 here in Tallahassee, and the weather was sponsored by Why Prescribed Fire, so that was kind of neat to see our ads on that. I haven't gotten the final report yet, but I did get some kind of rough numbers from Tall Timbers. And so in the 4 markets, there were 460 TV spots, They also did some TV stream. I don't know what these terms mean. I'm just putting what he put in the email, but so we had 75,000 impressions on TV streaming placements. I'm guessing that's if you're watching the news on a device as opposed to on broadcast television, which is how I watch it because I don't have cable anymore. But the good news is it increased our traffic to the website. So we had, over 5,000 visits during the time frame. And also they noted that, the spikes in the viewer or the visits to the website corresponded with the ads on television. So it did work. So I'm expecting the final report from them by the end of this month. And, we'll have some good numbers for that. So, in the fall meeting, I'll have some really good numbers for this report. So moving forward with this campaign, it's really going to be depending on funding. The initial project was for 3 years. It just wrapped up this past month. We will still continue to promote, during prescribed fire season, using social media. That's fairly inexpensive, for our folks to, like especially during prescribed fire awareness week, things like that. So we'll still see the term, why prescribed fire. I think there were some decals out on the table out there. It looked like they got scarfed up pretty good. So, and like I said, the organic social media, that just means, our agency partners and ourselves, can put out things on social media basically for free to, promote the campaign. So anything we can do to help raise awareness for burning. So, which is really kind of weird. I went to a physical therapist yesterday and she asked me what I did for work. And I told her I drive a computer all day. And, but then, I told her what I actually do. And she was saying that her dad is a biologist or something. And she didn't understand why in California they weren't doing control burning like we do here in Florida. So there are people out there that are getting the message. So that's good. All right, burner review. Again, this is our standard stuff. I know a lot of people today have said, they got my yellow letter. So that's important, to keep your information current, right? So your mailing address, your email. So how many got an email with the letter? Okay, how many of you also got it in the mail? Yeah, so I was doing a big thing, right? I was going to email out 500 letters this year, so that would save me from having to stuff 500 envelopes, which I did. And then I proceeded to forget that I did that, and I mailed them in the envelopes anyway. So I didn't really save myself any work. But so, tried out the email thing seemed to work pretty good because that way you have it in your inbox somewhere and you can hopefully find it. So if you would, keep your information current. And I'll get to that in a little bit, how you can do that yourself. And also it's important, let the duty officers know that you're doing a certified burn. When you call in or, the thing pops up that says, Tony Grossman is a certified burner. It's just a pop-up. They click it out of their way so they can continue what they're doing. It's not until later on in the process where they actually have to check the box for certified or not. So just make sure that they get that checked. So one way you can avoid having them to do that is if you go in and log into WebOBA yourself to submit the request, you can check the box yourself. And so that way you make sure that you get credit for that as a certified burn. Another good thing about logging into WebOBA is you can check your status. So when you log in, I know it's kind of hard to see on there, but it tells you on there, I call it the good through year. So it says, good through 2024 on education and 2022 on burning. I guess I need to do some burning because mine's expiring at the end of 2022. But so this is how somebody was asking me today, hey, I did some burns. I did one burn this year. Do I need to do two? I said, well, I'd have to look it up, but you can look that up yourself. So if you log into WebOBA, this is real time. If you needed to do two burns and you did two burns last week and you checked it today, it would be updated in the system what your date is. So this is real time. Now it's not, what's not real time is the education. So if you check it tomorrow, it's probably not going to say that you attended this meeting because I haven't gone in yet. I got to manually enter in your education stuff, but the burning requirement's automatically done through the system. Unless you use participation to maintain your status. So as you know, to keep your status, you have to conduct 2 certified burns yourself within the previous 5 years, or participate in 5 certified burns in the previous 5 years. When you conduct the burns yourself, the system tracks that on the computer. It's automatically tracked. If you participate, that's not tracked. So you need to fill out one of these forms and send it in to me with your burn participation information. And again, I manually enter that in and it'll update in the system. So be sure and keep track of any burns that you participate on if you're not able to conduct them yourself. I do encourage people to try and do at least 1 burn in your name each year. That way, you know, if you can do it every year, you don't have to worry about it. If you miss a year here and there, you still are in good shape and you shouldn't have to worry about your certification lapsing. Again, things to remember as a certified burner. Prescription is a legal document. Make sure the information is complete. You know, in the training you were taught, you know, all the required elements that are on the prescription. If you use the Florida Forest Service burn plan form, it's got all those elements on there. Make sure everything's filled out. Make sure the stuff that's filled out makes sense for the type of burn you're doing, and make sure that the weather parameters make sense and that you're burning into those parameters, because all that matters. You know, if something goes wrong, they're going to look at that burn plan. You have to sign it, date it, write down the authorization number, take it with you to the burn. Need to be printed out on paper and out the burn site. And also, it's a good idea to keep it with you. You know, keep it in your files. For one, they'll let you know, just a record of when you did the burn. But, for legal purposes, if something comes up later that you didn't know about right away, you'll have that in your file.
John, you are now requiring to keep it for a year after the burn takes place, I understand it.
Okay.
On file.
I mean, that's a good idea. I would, people ask me that all the time. I would keep it for at least 5 years, 5 to 7, just to have it,
Sure.
for records. But I don't know of anything that that may be something that's suggested, but I don't know if it's written.
If it's not here already.
Okay. And then there at the bottom again, like I said, tell us that it's a certified burn, because if you don't tell us and we don't check it, it's not in our system as a certified burn. If something were to go wrong, then you wouldn't have the liability protections that we will discuss here in a little bit. All right, so that's my quick down and dirty presentation. Does anybody have any questions for me real quick before we bring up the attorneys? Awesome, no questions. All right, so here's Darby Shaw and Kellyanne Kennedy. Thanks.
Hello, I'm Kellyanne Kennedy. I work at FDAX in the General Counsel's office with Darby Shaw. And although I cannot give legal advice, I'm here to discuss the prescribed fire liability threshold that is set at gross negligence. So I want to start with a little bit of background, because I think that it explains why the standard is the way it is. So in the 80s and 90s, burning was declining. And so the legislature responded to that by creating the Certified Prescribed Burn Manager program. And that helps insulate some of the liability exposure that is generated from prescribed burning. However, a few years later, they further strengthened that by increasing the threshold for liability from ordinary negligence to gross negligence. The purpose is to give landowners peace of mind so that they can burn. This is a right to burn state. So we want to encourage freedom to burn, and being able to do so without fear of extreme liability was a driving factor in raising the threshold for liability. Basically, the way the negligence standard works is there's ordinary negligence and gross negligence. Ordinary negligence is just a duty to refrain from harming others. Everyone has a duty to do so. And if you're burning and someone is harmed by your burn, then you could be sued for negligence. But if you are a certified prescribed burn manager, then they'll only win that lawsuit if you were grossly negligent. So under the gross negligence standard, even if you do accidentally cause harm to others, you're not liable unless you acted recklessly with regard to the danger. Gross negligence is harder to prove than ordinary negligence. Instead of merely proving that the certified prescribed burn manager accidentally caused an accident by acting unreasonably, the plaintiff would have to show something more than unreasonable behavior. They would have to have evidence of the burn manager consciously disregarding an apparent risk. And the issue here with insurance, this is when insurance comes into play, is this does not mean that you would not still get sued as a burn manager. While prescribed fire insurance is designed to protect burners from the cost of a lawsuit, efforts to absorb the cost of litigation may have an impact on insurance premiums. So even though the certified prescribed burn manager in most cases is very likely to ultimately win the lawsuit with the gross negligence standard providing that liability protection, the cost of defending the lawsuit is still incurred by the defending party. So that would be the burn manager, the burn manager's insurance company, if they have it. And that's where we stand today with the current laws and statutes. We have a memorandum on the subject and we brought copies. Thank you, Darby. So I would be happy to hand those out to anyone who's interested. And we also are happy to take questions, but that's just a general overview.
Who determines ordinary or gross negligence?
Great question. That's the fact finder. In some cases, it's the judge presiding over the case. Oftentimes it's a jury. And so it's totally dependent on the facts of the case and the evidence presented at trial, whether the jury is persuaded or not by the evidence.
How much, just general ballpark here, I'm not gonna hold you to it, but how much would it cost to defend yourself if you got sued from the fire? Now, roughly, I know lawyers, a good lawyer is $100, a few $100 an hour. So how many hours would they have just working the case to get you off based on the burn laws that you were not gross negligent? But roundabout, what do you got to come up with on the front side to get out?
So the question is, what is the cost of paying for an attorney to defend yourself? And roundabout. Obviously, that's going to be very fact dependent. And so I can't give you even an estimate, which I know is frustrating. I'll also add that Kellyanne and I are state employees, so we do not get that $100 an hour. So I wouldn't know anything about that. But I guess the takeaway is that, yes, there is going to be a cost to defend yourself. Unfortunately, there's no way to write a statute that says, you know, you have a blank check to do whatever you want as a certified burner. Anybody can sue you at any time, even if you do everything right. So the best advice that we can give you is, you know, follow your burn plan, follow the laws, put your attorney in the best possible position to defend you if it comes to that.
But can you agree that it'd be thousands of dollars?
I can't.
I think we have another question. Yeah.
In the back?
Can you talk a little bit on kind of the balance between the gross negligence and the onus versus the defendant versus the plaintiff, and kind of the burden of proof, rather, you know, because it kind of, you know, some of the other states, the burden of proof is a little bit different. And can you all kind of talk a little bit about why the defendant might have to defend themselves in court rather than that the gross negligence law kind of kicks in before that?
Okay. Let me try to restate the question. So you're asking us to talk about the burden of proof and how that applies and how gross negligence factors into that. So the burden of proof in a civil case where you're being sued for money, basically, is a preponderance of the evidence. And that's just a fancy way of saying more than 50% sure that you're at fault. So the burden of proof doesn't change. When we're talking about negligence versus gross negligence, I like to think of it as kind of a spectrum. So negligence is on one end where you're acting reasonably, but there's an accident. You should have known not to do something, but you did, and it caused damage. Gross negligence on the other end of the spectrum means that you're acting recklessly, that you're doing something consciously, that you've ignored something important, and that's what caused the damage. So it's a higher standard. So if you're doing, and it's going to change, right? No matter what the circumstances are, it's always going to be different. So say you're burning on a windy day. Well, what might be ordinarily negligence on that day could be gross negligence on another day. Lighting the fire at all on a particularly windy day, maybe that's grossly negligent, whereas lighting the fire on a not so windy day could be ordinarily negligent. So I'm kind of talking in circles here, but I guess the main crux of the issue is, what does the defendant have to show to hold you liable? And showing gross negligence is much more difficult than showing ordinary negligence. Sorry for the boring law school lecture. Yes.
Did I understand correctly that if you are not a certified prescribed burner, are you still protected at the negligence level as opposed to strict liability?
That's right. So if you're not a certified burner, the duty will be negligence, or the standard will be ordinary negligence. That's right. Sorry.
Is there any caps if it's certified and you're not gross negligent, like a cap to how much they can sue you for?
No, damages will be determined, based on the effects of what's happened. And
Just a hypothetical.
We'll get to God.
You're not grossly negligent, and it gets out, a neighbor's shed burns down, and that shed was worth $10,000 manhole. It was $10,000. Okay.
Hypothetically.
So they sue you, and you are found not to be at fault because of the gross negligence. Does their homeowner's insurance then kick in and pay for a shed?
So I
Who
can't,
pays for the shed?
so I can't answer questions for an insurance company, but I can tell you sort of a sanitized reading of the law. That's probably what should happen. If you're not held liable under the gross negligence standard, well then if I'm the homeowner, if I'm the homeowner, the next thing I'm going to do is call my insurance company. In the back.
I hear burn managers mentioned here quite often. I haven't heard anything about the liability for the landowner. And it's my understanding that the ultimate responsibility rests with the landowner rather than the burn manager. Discuss that.
So the question is, how is the landowner involved in liability? And I'll tell you that a good attorney is going to sue everybody. So the landowner is going to be right there with you. And that's why they hire certified prescribed burn managers, because that's protection for them too, right?
With the insurance is an extra.
Right. Oh.
So you recommend that if you are the landowner or the certified burn manager, that when you go to burn something, to get burn insurance, and if anything, no matter how many I's you dotted, T's you cross, you're perfect. If anything fluky happens, that insurance that you get will help pay for when someone wants to sue you or go after you. Is that correct?
So the question is whether we're recommending insurance, and the straight for the burner. Okay. Well, either way, I can't recommend one or the other at all. It's going to be a personal choice, right? You're going to have to weigh your risks and your ability to pay if something happens. So that's really going to be a personal choice. But if you're my client, the answer is yes.
Is Florida a loser pay state?
A loser pay?
If you go to court and you win, does the other side pay your legal fees?
That's a good question. So the question is whether or not the loser in the lawsuit will have to pay attorney's fees. And that will depend on your fact finder and whether the judge assigns that as part of the damages. So that's a possibility, yes.
That work both ways. If somebody sues me as a burner and I win, can I get them to pay my legal fees?
You can ask that they be required to pay your attorney's fees, yes. I would say it's probably pretty uncommon that they would be awarded. It would have to be like a malicious lawsuit for that to happen,
Not
typically.
just frivolous, but malicious.
Well, maybe frivolous is a better word.
Do you know if it's, if this has been tested in the courts much or in most cases? So either by the company or burner or their insurance company, how often has the gross negligence actually gone to court and been, adjudicated one way or another?
So the question is, how often has this been litigated in court? It has been, but not very much. The follow-up to that was, are these cases typically settled? And I think that kind of gets us to the problem that's been floating around today with insurance companies, right? Because they don't want to take the risk of litigating and possibly losing. So they end up encouraging settlement. And most attorneys are going to encourage settlement because, one in a hand is better than two in the bush. And so, you settle these lawsuits and you never get to the point where somebody decides whether or not you are grossly negligent.
If it did go to trial and you had a jury, I mean, that could throw everything one way or another. And you can't make, y'all assume from other cases in the law, the literature being tweaked and all, but doesn't it always come down to 12 people or, I'm not lawyer, but yeah.
So the question is, aren't juries a gamble? And the answer is yes, they are. So the question is, and I don't know if y'all can hear the question, so I'm repeating them. I hope that's helpful. Is whether or not the landowner hides behind the gross negligence standard of the burner. And yes, they enjoy that same standard so long as they've hired a certified prescribed burner. Now, if they hire someone who's not certified, then they won't have that protection. Anybody?
I gotta go back. Tyler had the hypothetical about the shed burning down, but who was to pay for it? Or if the landowner of the shed you burn down was to sue you, wouldn't it be them suing the state of Florida since the state of Florida issued you the permit to burn? So they gave you the right to burn.
So the question is whether the state has any liability for issuing the burn authorization, and it's actually in statute that we do not. But nice try. Typically, that's how the insurance company would proceed.
And they've always got the best lawyers.
I don't know about that. I think the best lawyers are with the state.
I used to work, when I got out of college, I worked for the Florida Forest Service I never pulled permits, but the question has arisen, what protections do government employees that are certified burners that pull a permit and it gets away, are they ever named in suits, or do they have any worry that they're going to get named in suit working for the government? Does that make sense?
So let me see if I understand. Do government certified burners, are they ever named personally in a lawsuit?
Correct.
I've not seen that. I would say it's possible because you can sue anybody, right? But typically, an attorney is going to go for the bigger pockets, which would be the state agency.
An answer to that question is yes, as a federal employee, I carry professional liability insurance. So I can't be named.
Well, thank you guys for your time. Please pick up our memo on your way out.